Okay, good morning. My name is Tammy Kleins, and I am an executive board member of the Mayfield Area Chamber of Commerce. We are excited to have you here today in the final session of a four-part series on operating your business during a pandemic. This series is brought to you in collaborative effort with the Mayfield Area Chamber of Commerce in the cities of Highland Heights, Mayfield Heights, and Mayfield Village. Today's webinar will be focusing on HR issues. The entire series can be viewed at the Chamber's website, mayfieldareachamberofcommerce.org. mayfieldareachamber.org, where you will find all other resources as well for your businesses. So I hope you actually stop by our website to see what we have to offer you. So now let's get started, and here's Chamber President Joe Cordetti.
Welcome everybody to today's session, HR and COVID-19. I want to thank everybody for attending, and like Tammy said, the presentation will be up on our website as well. And today's presenter is Liz Crosby. She is a partner at Buckley King with 30 years experience in employment law and workers' compensation. So she's the right person to be giving this presentation here with all her years of experience. Liz is a member of the Cleveland Metropolitan Bar Association and the Ohio State Bar Association, where she serves on the Labor and Employment Section Council. She's a member of the, Cleveland chapter of the Employment Law Ends, and and she's also been named an Ohio Super Lawyer yearly since 2010 and is one of the top 50 women attorneys in Ohio and top 25 women attorneys in Cleveland. Liz is on the board of directors for the Willoughby Western Lake County Chamber of Commerce, a Drink Local, Drink Tap, a local grassroots advocacy organization fostering sustainability and access to clean water. So Liz had said, if we get through this presentation quickly, she's happy to answer any questions. So we'll have to just monitor the time and see how we're doing. But without further ado, I'm going to turn everything over to Liz.
Good morning, everybody. Can everyone hear me? Just shake your head if you can.
Yes.
I'll make sure. Okay, great. Sometimes I forget to unmute. Thank you very much for having me today to speak to your chamber. And let me just get started here. This is what our agenda is. And the first part, are we back to work yet, really is focused on the Director's Stay Safe Ohio order. I'm assuming almost everybody is pretty familiar with that, but because the second two topics, are we in trouble yet, and Back to the Future, are dependent upon compliance with that Stay Safe Ohio order, I want to just go through it relatively quickly. We have a smaller group today, so if you want to stop me at any point and ask me a question, I welcome that opportunity. And because I'm here to help you, and help guide you in some of this. The questions that I've had during this time period have kind of blown my mind. I've learned a lot. I'd like to share what I've learned with you. So let's go ahead and get started. Almost every industry is back to work. I'm a little disappointed that the playgrounds aren't open and the swimming pools are still closed. It's making it hard for parents to be parents, but for the most part, those of us who have jobs are pretty much back there. So what does that mean for us? I put a link up there for the Director's Stay-at-Home order. If you haven't had a chance to grab it and keep it as a reference, you can actually screenshot this. It has the link on there, or if you just Google Director's Stay-at-Home order Ohio, it'll come up for you as well. And it identifies everything that Ohio businesses are required to do. So basically, it's consistent with what we've done during the essential business time period. We've got to take proactive measures to ensure compliance with distancing, sanitization, separating vulnerable populations, and one of the new things in the stay-at-home order is if you've got an online presence, you've got to post whether your facility is open, how to reach it, and how to access your services by phone or remotely. You may actually see this as you go out into the community, that businesses have signs up, we will bring the product to you, we will meet you at your car, here's our phone number, etc. That's part of that compliance. Here is probably and a few of us were chatting before we started this morning, this is probably the most controversial and difficult aspect of the stay-at-home order, and that is the wearing of face coverings. In a work setting, face coverings are required unless they are prohibited by law or regulation. So it is my understanding that in banking, they are prohibited because that's what bank robbers wear. I happened to bank at a credit union, and all of the tellers had them on, and they didn't permit me to go in without one. So I'm not entirely sure that that law, reaches across all boundaries, but I have been told that banks prohibit the use of face coverings. The other 3 exceptions to the requirement to wear face masks are that it's a violation of documented industry standards, or it's not advisable for health reasons, or it's a violation of documented business safety policies. Facial coverings are not required when an employee works alone in an assigned work office. And if there is a functional or practical reason for an employee not to wear a facial covering in the workplace. However, with respect to that last one, the business must provide a written justification upon request explaining why an employee is not required to wear a facial covering in the workplace. Now, before I go any further, the reason that these laws and the written justification and what have you exist is not because the government is out there looking or you're going to be audited in any kind of way. It's because there is always the rogue employee who is going to report you. How many of those phone calls have I got? Probably at least 3 a week since this whole thing began. So any problems that an employer is going to run into with respect to compliance with the Director's Stay Safe Ohio order, it's going to come from your internal workforce who either just wants to create trouble or has a sincere concern about their safety.
Hey, Liz?
Yes.
So 2 quick questions. Is that any business of any size? And in my organization right now, I'm not wearing one. My CSR isn't, but my other assistant is. Should I have somebody sign off if they say they don't want to wear one?
Scott, you're insurance, right?
Yep.
Because I remember you, Scott.
Of course you do. Hard to forget. Mary Alice.
Full disclosure, Scott and I served it on the Willoughby Chamber together until he left. Your employees are primarily in offices until they go out into a common area, correct?
Yeah.
So you would be under one of those exemptions.
Okay.
And we're in the same boat as a law office. What we've done is we have a pack of face masks available when you come through those doors. We have not required the use of them. We have invited folks to let us know if they're uncomfortable in working in an environment where people are not required. I will tell you that we have one employee that consistently wears a face mask, and that's it.
Okay.
We have probably in the neighborhood of 30 people reporting to work every day. So would that employee contact the Department of Health? Maybe. And at that point, I will make sure we have a written documentation on why they're not necessary, which will have a lot to do with the fact that they're not working on top of each other.
Gotcha. Thank you.
You bet. So paragraph 20 of the Stay Safe Ohio order gives you the checklist. And again, I'm going to assume that everybody's familiar with this, but I want to highlight a couple things. One, it is still important to strongly encourage employees to work from home if they can do so, and if it does not adversely affect your business. So keep that in mind, and that's particularly true if employees continue to express a desire to work from home. Whoops, that's the same thing. Also, actively encourage sick employees to stay home. Actually, this is how it's written in the order. I'm going to tell you that if you've got a sick employee, prohibit them from coming to work. You don't know what they're sick with. And the way that this disease has manifested, it's got some pretty basic, familiar symptoms, the fever, the cough, but not everyone manifests COVID in the same way. And so if they're sick, certainly if they have a fever, certainly if they are exhibiting signs of illness, go home. Do not come in here. Do not bring that with you. The order also says not to require a healthcare provider's note to validate the illness. This was really written at the very onset because we were very fearful that healthcare providers would be overrun. I'm going to tell you that the calls I get of the people who aren't sick but are afraid to come to work or claiming sick has been a lot more than the people who are actually sick. And I would require, if you normally require a healthcare provider's note, I would do so. That has to do with both, I'm out for 72 hours. You want to justify that they've been out for any kind of illness. And also when they return to work, I think you absolutely want a release to return to work. Third, make sure your sick leave policies are up to date, flexible, non-punitive. Again, if somebody's playing games with this, it's okay for it to be punitive. And encourage employees to do a self-assessment. I'm going to talk to you a little bit about the sick leave policies in the third part of this presentation. Separate employees who appear to have acute respiratory illnesses. Yes, separate them from your business. Don't let them come to work. Reinforce key messages. Again, at the outset of this, we sent a message every single day. If you're sick, stay home. Please practice hygiene. Please provide protection supplies. We continue in my office to make sure that temperatures are taken, that our office is cleaned 3 times a day at least. And you want to send that message to your employees for 2 reasons. One, you want to do the work because it will keep the workplace safer. But second, again, with the rogue employee, you want to be able to look back and say, hey, this is what we've done to keep our employees safe. We talked about the environmental cleaning. Appoint someone to do that. If you're in a manufacturing industry, it's essential. If you're in an office situation, it's highly recommended. And then finally, be prepared to change your business practice if you need to. If you need to move desks, put plastic screens up, whatever it is, in order to comply and keep people safe, be ready to do that. And obviously comply with all the guidance from the CDC and the Ohio Health Department. So there is paragraph 21 of the stay-at-home order has specific guidance for industry. Is anyone here in the manufacturing, distribution, and construction industry? Okay, so regardless, there are overlaps which are very consistent again with what we've already been doing, but it's certainly in the consumer retail services and to some extent in manufacturing and distribution, there are enhanced requirements with respect to putting up screens and separating employees more physically. Excuse me. That's just a tickle. It is not a COVID cough. Okay, so here I've listed out what some of those paragraph 21 requirements are. Shutting down the shop floor for deep sanitation if possible. That's going to be a requirement if you actually have someone test positive. All right, any questions before I move on to are we in trouble yet? Those of you in HR, are we in trouble yet? This has to do with those employees who are looking to create opportunity in the midst of the pandemic, and they're out there and they are making themselves known. One of the early questions I got is, could these be workers' comp claims? And the short answer is no. It is highly unlikely that a COVID claim, a COVID disease would ever be a workers' comp claim. And the reason for that is the Ohio statute for workers' compensation, which now I'm going to dazzle you with my intelligence, Ohio Revised Code 4123.68, lists all compensable occupational diseases. And there is a kind of catch-all phrase that says, if an individual is exposed to something in a greater degree than that to which the public is exposed, then that might be compensable. Now, no one generally is exposed to COVID greater in the workplace unless they might be a first responder and healthcare worker. So I can see maybe an argument that those might be compensable claims, but for the general population, you're not going to have a workers' compensation claim for COVID-19. I noted there that you've got but for employment injuries and diseases, but for my employment, I developed COVID-19. The only other distinction I want to make on workers' comp is, and we're going to talk about this in just a minute, but under the remote workplace, if an individual is not in your work and they are working remotely and get injured working remotely, i.e. they trip over their dog, and yes, that's a real case, that might be compensable. And so we want to have some policies in place to prevent home accidents becoming workers' comp claims. But generally speaking, COVID-19 is not going to be a work comp claim. OSHA claims. So under OSHA's general duty clause, the employer is required to furnish an employee with an environment that's free of recognized hazards. So long as you're complying with all of the Department of Health, both the CDC and the Ohio Department of Health, you're going to be deemed in compliance with the general duty clause of OSHA. Now, a couple things that are kind of interesting. Before COVID-19 ever hit, OSHA had guidance with respect to coronavirus diseases, which is the COVID. This one happens to be number 19, that gives general guidance. What you'll notice there is that it is absolutely consistent with what we've already been instructed to do. Please note the personal protective equipment that's required and respiratory protection. So, Scott, going kind of back to your question, is it required? If you have a sense that your employees are exposed to a bloodborne pathogen of some sort, or might be because they're in the workplace, you must provide that respiratory infection or protection. When would that be advisable? If you've got people in there coughing, of course, I'd send them home, but if you've allowed them to permit it, I'd make them wear face masks. And then the hand washing, cleaning and disinfecting work surfaces, everything we've already talked about. If you have enhanced interest in what OSHA requires, they've got 3 workbooks out there. One is the what to do during a pandemic. The second is specifically related to COVID-19. And the third, likewise, is preparing the workplace for COVID-19. So if you're in an OSHA targeted industry, that would be manufacturing and some industries where there's a great deal of injuries, I would take a look at those. One other question that I've had a lot about, a lot of questions on, do I need to call OSHA if I have an employee test positive? And the answer to that is no. OSHA has, generally speaking, under the old COVID, they wanted you to call within 24 hours of an employee being hospitalized. Apparently they realized that that was going to generate a lot of foot traffic in their office, or at least a lot of phone traffic, and so they put the kibosh on having to report COVID-19 illnesses in the workplace. Okay, another question I get a lot is on HIPAA. And this really relates to, I can't tell the rest of my employees that we've got somebody sick. First of all, I really want to hammer this home. Employers are not covered entities under HIPAA. HIPAA applies to any organization that is dealing with general healthcare information. So hospitals, they've got a boatload of medical records for a lot of people. Healthcare clearinghouses, like your managed care organizations, or someone that works electronically with hospital records. That would be your billing companies. That would be the organizations that maintain hospital records. So generally speaking, unless you are one of those three bullets, you are not a covered entity and you are not required to comply with HIPAA. Does that mean that it's okay to go out and say, hey, everybody, Joe Smith has coronavirus 19? No, it does not mean it's okay to shout it. It does mean that you cannot be sued under HIPAA if you share that information. There are other privacy concerns about people's protected personal information, but HIPAA is not one of them. So that's mostly for your personal relaxation. So what other kind of claims can come up as a result of the coronavirus epidemic? A lot, and I see this a lot, and I'm pausing a little bit because there's a practical side to me that guides employers, including my own firm. And then there is the side of me where I have to be a little more politically correct. But some people have seen some opportunity in layoffs. Fair enough. And so do we have to bring these people back? Can I selectively bring people back? I've got one client that is dancing a jig because they've been trying to figure out a way to get rid of somebody, and this provided the absolute best way of doing it. Here's my advice on that. If you're in callback mode, make sure that the criteria you are using, if you're not bringing everybody back, make sure the criteria you are using relates to an objective, definable, legitimate business purpose. If you've got job descriptions, hallelujah. If you don't have a job description, make sure that you are doing due diligence. I would actually get a piece of paper out, write the most important job duties that you need to have done, and write down the people who possess the qualifications to do those. Hopefully at the end of the day, the employee you don't want doesn't fall in any of those talents. If they do, you may have a problem, particularly if that person is has a protected class status. And those protected class statuses that are going to be most important at this time, number one, disability. So if you're letting somebody go because they got sick, that's kind of a problem. And then again, age, oh gee, they're in a class where they could get really sick from this. We're going to be paternalistic and say, you're too old to work here, you're at risk, don't do it. That will get you in trouble. Sex, whether you're making the decision because you don't want what men or women in the workforce, again, that's an opportunity for a lawsuit. And then of course, race and color. And those types of claims arise with the termination, the failure to call back, and any demotions you might put in place as a result of this. So just make sure, again, that you're going through your checklist of the essential job functions and matching people up appropriately. Okay, wage and hour claims. I don't see a lot of opportunity here in COVID-19 for folks with wage and hour claim, except for the remote worker. And why is that? They're not clocking in and they're not clocking out unless you've got some mechanism or requirement that they do so. The Fair Labor Standards Act says that you must pay an employee for any hours worked or suffered or permitted to work. I worry about that phrase, permitted to work. You're home, we aren't paying attention, that's permission. So if you're dealing with remote workers, and I'm going to talk about this when I give you the recommendations on how we move forward, we're going to have contracts. We did it with all of our remote workers, and they're like, are you kidding me, Liz? And I'm like, absolutely, I am not kidding you. You are signing this. And one of those workers calls me and says, you know, we limited that particular individual to 30 hours. And she calls me and she says, Liz, I'm at 29 and a half hours and I can't get this work done. And I'm like, save it for next week. So I give her credit. She always checks in with me to let me know. But that's one way we have been able to manage not only the remote workforce, but also our in kind of business practice during this time. So how many of you are familiar with WARN? Maybe you could just raise your hand. Greg, I don't see your hand. So WARN is an old law. I say old. It was actually authored by Howard Metzenbaum, so those of you who remember him. And it really came about in the late 70s out of all the plant closings that were going on. And basically what it requires is that if an employer has at least 100 employees, they have to provide at least 60 days notice before laying off a third or more of the staff. I'm not going to spend a whole lot of time on this. I don't know if any of you work in an organization with at least 100 employees, but there are two exceptions to WARN, and that's why I'm not going to spend a lot of time on it. I do raise as an issue because now we know what happens in a pandemic, and if we see this coming again, these two exceptions may not apply. The first one is unforeseeable business circumstances. Certainly that's what we had here. On or about March 12th, we were told we are shutting down Ohio, we are shutting down the United States. That is unforeseeable. And once those, you know, those restaurants that closed, boom, there was no notice on that. They were shuttered. The other exception is a natural disaster. And I think to some extent, a pandemic qualifies. It doesn't actually say that, but it is a natural disaster. It's a disease process. And so anyway, that would exempt employers with at least 100 employees from having to comply with WARN. So what do we do going forward? Are we going to have a second wave? Is it possible that this is going to hit again? I can tell you from my own perspective, I think we've learned a lot. I think there's a lot more for us to learn about this. This disease can mutate. It didn't just happen. We've had SARS viruses, there's Ebola out there, there's all of these microbes that we can't control. And can it happen again? You bet. We live in a world that is very, very congested in many places. And so clearly this can happen in the fall, it can happen 5 years from now, and I think we need to be prepared. So the things that I've learned in guiding my clients through this. First, when we get the compliance requirements from our government, we got to follow them. And the second, we've got to have our policies updated. So one of the compliance issues that came out of this, and I'm kind of taking a slightly left turn, I'm also going to assume that most of you are familiar with the Families First Act. This provided relief to workers. HRs needed to be very familiar with this. But I want to touch on it real quickly because the Family First Coronavirus Response Act is not retroactive. So if you didn't lay people off, or if you had people take time off before April 1, they were not eligible for this. But more importantly, it expires on December 31st. So your paid sick leave under the Family First Act isn't available after December 31st. And the paid leave for childcare is not available after December 31st. Very important. With respect to the compliance issues, this is a copy of the poster that the Department of Labor has required be hung in your workplace. Again, there's the link for it. Scott, is this hanging up in your office?
Not yet, but it will.
It will be, won't it?
Yes, yes.
So yes, so take a screenshot of that link and print that off and put it up right next to your workers' compensation coverage certificate.
I do have that.
So basically, this just is a mechanism of notifying your employees what their rights are under the Act. A couple other important issues I want to bring to your attention about the Families First Act. It applies to nearly every employer. If you've got one employee, you've got to comply. Now, why that is important to note is that this is basically a companion to the Family Medical Leave Act. The Family Medical Leave Act only applies to employers with at least 50 employees. That becomes important in just a second when we talk about what kind of benefits and how we coordinate those benefits with the Family Medical Leave Act. The FFCRA must have some direct connection to COVID. So if an individual says, I don't feel good, I have COVID symptoms, but they haven't been diagnosed or are awaiting a diagnosis or have been told that they may have COVID, they aren't eligible for the leave under this. And if they're caring for someone with COVID, that's only available if no other caregiver is available. Really, really important. This, what is it, the fifth bullet. It reduces regular family medical leave. So under the Regular Family Medical Leave Act, which applies to employees with at least 50, employers with at least 50 employees, they get 12 weeks of unpaid leave in a rolling calendar or in a regular calendar. If they've taken 12 weeks to stay home with kids, boom, their family medical leave is gone for that 12-month period. For every day they take FFCRA leave, they reduce their regular family medical leave. Really important. Two other really important aspects of it. They've got job protection. If they have taken this leave, you don't get to say, I'm sorry, we don't have a job for you, unless they would have been part of a layoff regardless. And based on some of the requirements, they may not have been eligible for that leave if they were going to be part of that layoff. For example, if it was announced before they decided to take the leave. Finally, anyone taking leave under Family Medical Leave or the FFCRA, you are required to continue their health insurance benefits. And I would recommend a liberal, some liberal assistance in helping them cover their portion of it. I also want to, and I don't have a slide on this but it's a question I get a lot. If you've laid somebody off and you haven't brought them back yet, or you're wondering, you know, what is the difference between termination, layoff, and furlough? There really is no legal difference. A termination is permanent. You're not coming back. Good luck. Have a great life. A layoff suggests that there's a possibility that you're going to come back, and a furlough strongly means we're bringing you back. So if you've furloughed someone and they have an expectation of returning to work, those benefits should be continued. If they've been permanently laid off, they're eligible for COBRA. Okay. And here, this is just a chart which explains the types of serious health conditions and disabilities for which there is protection, one under the Family Medical Leave and the other under the ADA. Under either of these, employers are not required to pay their employees if they are off work. I'm not going to go through that with you today, but it's a quick reference for you. And I have made the slides available through the chamber. All right, and now I'd like to talk about what kind of policy updates you should have going forward. The first one, I find this one really interesting. Years ago, I was asked to create a communicable disease policy that no one ever used and no one ever wanted. And I really never understood why, because, you know, as both an employee and an employer, when somebody reports to work sick, I find that incredibly irritating and frankly disrespectful. And employers have a right, even before COVID, to send people home if they're sick. I recommend that every employer have a communicable disease policy that gives you written documentation so that somebody doesn't say you're singling me out. No, you're hacking, you're sneezing, you look like you have a fever, and no one wants to be near you. Go home and get better. So if one time only for Mayfield Chambers members only, if you want a communicable disease policy, I will send it to you. Just email me, and you can fashion it to fit your business model as need be. But I think it's a really important policy to have in place. It also says employees may be required to obtain a physician release to return to work, and that's for their protection and yours. Here's really one of the most important things you should have is a remote work policy. And it isn't just a policy, it should be a contract with each employee who is working remotely. Why is this important? Because there are a whole host of considerations that when somebody says, go ahead and work from home, you haven't even thought about. First of all, it gives you the permission to make sure that the environment in which they are working is safe, not just for their physical well-being, but also your intellectual property and your physical equipment if you're sending them home with computers and routers and whatever else. So the first would be, whoops. Uh-oh, what did I do? Okay, we did that one, right? All right. Sorry about that. I have an Apple mouse pad that if I touch it wrong, this is what it looks like. It goes skating all over the place. First thing you want to have in your remote work agreement or remote work policy is compliance with your handbook. So you don't want anyone to think that because they're not in the office, the handbook policies no longer apply. They absolutely apply. So the first sentence is going to be, by agreeing to work remotely, I agree to be bound by the terms and conditions of my collective bargaining agreement or my handbook or whatever rule policy manual you have in place. So they're going to adopt that. Second, you want the agreement to address any equipment. First of all, if they're using their own equipment, such as I am right now with my Apple computer, I agree that I own it, I'm responsible for maintaining it, and if something goes wrong with it, it's not my employer's problem. Likewise, if I'm using their equipment, I'm going to agree to responsibly maintain it, alert my employer if anything goes wrong with it, because hey, my friend Joe, who lives 4 doors down and says he knows all about computers, I'm just going to have him come down and fix it. Holy Moses, you do not want a stranger working on the company's computer equipment for a lot of reasons. And if your employee breaks it, who's going to pay for that? I know most employers are going to go ahead and pick up the bill, but I think you want your employees to feel that they got a little bit of skin in the game on that one. Okay, data security. This is really huge, and I'm only scraping the surface of this topic. But a couple things that you want your agreement to note. First of all, I got my grandson in 2 rooms away from me right now. I might be having a very confidential conversation with one of my clients. He goes and he tells all the neighbor kids that I talked about X, Y, and Z, or maybe my husband did, or wow, I didn't know you had that going on with that company. That is a breach of confidentiality. So you've got to make sure that when your people are working remotely, that one, kids aren't getting on that computer and possibly damaging documentation, downloading viruses into the computer, uploading confidential information into the World Wide Web, and that they aren't within a listening distance of any communications you might be having that could be considered confidential. So you want to have a policy that says what can be uploaded, what can be downloaded, who can work in and around a remote work area, and who can use the same equipment that is being used for work purposes. If you really want to do something secure, have an IT company come and audit the remote workplace. Particularly in highly sensitive areas, companies will do that. Safety. So at the very beginning of this, I noted about the employee who tripped over her dog while working from home, and she was eligible for workers' comp benefit. That's the Sandberg versus J.C. Penney. You want to have, you may want to have a safety audit of the employee's work environment. Most companies aren't going to do that. We didn't do it. I'm not sure most employees working remotely want somebody coming into their home and auditing whether or not they're working safely. But it is an option. But certainly you want to have an agreement with the employee that that they will take all measures to create a safe and risk-free work environment. That they are required to immediately report any injuries they have, and that they're required to pursue medical attention. So let me tell you why that's important, because I see this all the time. They don't tell you that they've hurt themselves, and they come back to work and they start feeling like, oh, gee, I'm not sure I'm going to keep my job. I'm going to make a whole lot more money on workers' comp than I am, because all of that care money is gone, and I'm going to have a work comp claim. So, you know, did I tell you guys when I was working at home how I tripped over the cord of the computer? And it didn't really hurt at first, but it hurts really bad now. And I think I'm going to go get some medical treatment. That's a real problem. So we want to have the policy in place. At least we can go, if we have to defend that claim, and say, look, they never reported it. Second, you want them to get immediate medical treatment. If they really hurt themselves, they're going to agree to do that. If they didn't really hurt themselves and they go to the doctor's going to say, I found no bruising, I found no swelling, I found no signs of injury. And then you can defend the claim. So that's a summary of what I have for you today. I'm happy to entertain any questions.
Actually, I have one. I know that the state at order rule actually stops on the 31st, doesn't it? Doesn't it expire on the 31st? Or
the Stay Safe Ohio order?
yes.
You know, I don't know the answer to that.
Because what I'm wondering is how much longer our company is going to have to actually deal with this, because that order is going to be rescinded, I believe, at the end of the month.
Which is Sunday. Well, couple important things. So first of all, DeWine seems to give direction on Thursdays. He seems to issue new policies. So I think we should all listen to the 2 o'clock press conference today. Second, I heard on the news this morning, and I did some research before presenting this today, that that employers are now required to report positive findings to the health department. This was on Channel 5. I don't know if anybody else watched the 6 a.m. Channel 5 news. I tried to find the source for that and could not. So I don't know if that's true or not. Because this virus is still alive and well. We hit 100,000 deaths yesterday. I am guessing that these work safe provisions are going to continue.
Wow. Anybody else have any questions?
No, very good, Liz, as always.
Thanks, Scott. Well, it was a real pleasure, and please, if you want the communicable disease policy, or if you have any questions, feel free to call me, email me, and good luck with your chamber.
Thank you. Joe, you want to close out?
Yes, I can go ahead and absolutely do that. Liz, thank you again. That was excellent information. Again, everyone, this presentation will be posted on our website, and I believe we'll be looking to do more Zoom meetings in the future. So, things are changing daily, weekly in our world, so we'll just have to kind of take things one day at a time and see where this leads us. But I want to wish everybody a great rest of the day, rest of the week, and if anybody has any questions, please reach out to myself. You can reach me at joe@lakeshoreinsurance.com, or you can visit our website at mayfieldareachamber.org and reach out through our website. All right, everybody take care and have a great day.
You too, thanks.
Thank you.
Thank you all. Take care.